Good morning, everyone, and welcome to our second Reach Out Live, which is a new program of the Cleveland Metropolitan Bar Association's Reach Out for Nonprofits program. As hopefully some of you know, we switched to this format starting last month. Our usual format for the Reach Out programs is that we would hold quarterly seminars in the Bar Association offices where we would give a presentation on an issue of importance to nonprofits and the attorneys who advise them. Free presentations followed by brief advice clinics for volunteers and nonprofit leaders to get together and talk about what's going on in the nonprofits and give some quick advice. Obviously, with the spread of COVID-19, we decided that we wanted to keep everybody safe, but still bring the services of our volunteer attorneys to the nonprofits in our area. Now more than ever, it is incredibly important that we keep our nonprofit system going strong and keep helping each other. So we're very pleased to have the second of our Reach Out Live programs today. My name is Jessica Payne. I'm the Director of Community Programs here at the Cleveland Bar Association. And joining me are two of our wonderful members of our steering committee for Reach Out, including Jackie Very and Alex Campbell. Jackie is with Calfee Halter and Griswold, and Alex Campbell is with Buckingham, Doolittle, and Burroughs. We're pleased, as always, to have you folks join us. But we're especially pleased, of course, to have our new panelists join us. And again, thank you, Jackie, for bringing in your friends and colleagues to help us with our focus today, which is going to be on employment issues and legal employment issues for nonprofits. So welcome to Russell Rendell. He's from Brennan, Manna, and Diamond. We also have Todd Palmer, who is with Calfee Halter and Griswold with Jackie. So thank you so much for joining us, everyone. And with that, I think what I'd love to do is pass it over to Russell to say a brief introduction about your practice, and then we will kick it off with some of the pressing questions that we've got today. Really quickly though, I do want to remind everybody who's watching today, first, thank you for coming. But if you have questions, please feel free to use the Q&A button down at the bottom of your Zoom screen or pose questions on Facebook. We are streaming live. We will either incorporate them into the discussion as we're talking, or we will have some time saved at the end specifically for Q&A. So please jump in at any time. We will definitely do everything that we can to get to your question and get that answered. So with that, Russell, I'm going to kick it over to you. Thank you and welcome.
Hey, thanks very much, Jessica. So welcome, everybody. Thanks for being here. I hope you're all staying safe and healthy during all of this. So my name is Russell Rendell. I'm an attorney with Brennan, Manna, Diamond in their Cleveland office. They're based out of Akron, but have a Cleveland office as well that I'm working out of. My focus is on labor and employment litigation, primarily, also counseling clients on policies, procedures, compliance with labor and employment laws. And I've had the opportunity to work with a number of nonprofit clients as well over the past few years. Certainly appreciate the opportunity to speak with you all today. And thanks very much to CNBA's Reach Out group and to Jessica and Jackie for working on setting this up and allowing me to be involved with it. So glad to be here. As you probably know, the Ohio Governor's Office held a briefing last Monday to kind of lay out the Responsible Restart Ohio plan. And then near the end of the week issued a new order, stay safe order, stay at home order for businesses, which kind of aims at gradually reopening businesses while still maintaining a lot of restrictions and still maintaining the stay at home order with certain amendments. So that's something we can certainly talk about today, what kind of impact that's going to have on your organization, how you may need to adapt your policies and procedures in the office or otherwise. So the new Stay Safe order sets forth a number of what they call responsible protocols, which are kind of the headline from that order for all businesses to follow, and also rolled out some kind of sector-specific requirements for office environments for retail, which is set to reopen on May 12th, I believe is the date, and also manufacturing, distribution, construction. There's still a long list of businesses that remain closed, so that's going to obviously include schools, dine-in restaurants, personal appearance and beauty sort of businesses. You can tell I kind of need a haircut at this point. It's getting a little shaggy. So, you know, though there are a number of businesses that are going to remain closed, but there are some limited reopenings for retail and kind of encouraging people to get back in office environments. So as I was saying, the headline from that order were the protocols that have been put into place for businesses that are going to be operational, which may be applicable in your situation with your organization. So for employees who are in the workplace, face coverings are required with some exceptions. If you're in an enclosed office by yourself, or if you have a health reason that you shouldn't be wearing a face covering, and a few other reasons that may be applicable in some situations. The order says that businesses, organizations need to conduct daily health assessments for their employees. So that may mean taking their temperature on the way in the door, asking individuals about symptoms, or having employees conduct that assessment on their own and then reporting to their employer that they aren't experiencing symptoms, they aren't experiencing unusual a high temperature or anything like that that might be concerning. The order says that businesses and organizations should maintain good hygiene at all time, which means encouraging hand washing, sanitizing, and enforcing social distancing, so keeping people 6 feet apart or more in the office environment, if at all possible. It also indicates that there should be cleaning and sanitizing in the workplace. It should be kind of ongoing during the day, at the close of business, or in between shifts, depending on kind of your situation. And then also limiting capacity in your business. If you have outside vendors or clients or customers who are coming into your workplace, you should be trying to set appointments so that you limit congestion. And you should be putting in place practices that help enforce social distancing guidelines for everyone, not just employees. It also sets forth a protocol for dealing with if you have an employee or a client or somebody connected with your organization who has been infected with coronavirus, what you need to do as an organization to report that to your local health district and take further steps beyond that. Like I said, there are another number of kind of sector-specific operating requirements that it goes into, and I don't want to go into all of those in detail right now. We can certainly kind of open it up for questions at a certain point, and hopefully spend most of our time on that. Some of the other issues I'm encountering in the labor and employment area are paid sick leave issues, wage and hour issues. There are a whole host of things that are coming up, and hopefully, if you have questions, you'll feel free to ask us those things. I'm going to kick it over to Todd right now if he has any opening comments for us, and then we can kind of get into your questions and comments.
Very good. Thank you, Russell. I'm Todd Palmer. I'm a partner in Calfee's Labor and Employment Group. I've been practicing labor and employment law for 29 years, but only with a beard for about 6 weeks. And I agree with Russell. I'm eager for barber shops to reopen because then all of this goes away. Like Russell, it's been a very interesting last about only 6 weeks to 2 months for labor and employment lawyers. Seems like about every 2 weeks, something new comes along that we have to scramble to learn. And going back into mid-March, it was the FFCRA and the requirements for the emergency paid sick leave and the extended family and medical leave. And so for a good period of time, we were scrambling to learn those and address client questions about those. And those questions still continue. But then seems like right around early April, we got the next wave of new enactment, and that was the CARES Act, and especially the payroll protection, paycheck protection program loans, which have a fair amount of employment issues built into those loans, and especially the forgiveness formula for those loans. And then just as maybe people were starting to assimilate that, then we got the last Monday, the Responsible Restart Ohio program announced by the governor, and then as kind of formalized by the Department of Health Safe Ohio order that issued on Friday. So we have been staying busy in the labor and employment area for the last couple months. But in addition to serving clients, one of the things I do at Calfee is I'm kind of our Calfee's in-house employment lawyer. I advise firm management on employment issues affecting our staff and our lawyers. And as part of that, I've been on Calfee's COVID-19 response team and have been responsible for, among other things, drafting our own graduated return to work plan, which we have rolled out and we're implementing starting next Monday, May 11th. So I've done this at kind of the theoretical level, but I've also done it on the very personal level of the policies and practices that affect, my law firm. So pleased to be here and happy to entertain whatever questions you have.
Great. Well, I think the thing that's pressing on everybody's mind, of course, is, as you mentioned, Russell, the implications of the new Stay Safe order. I think now is as good a time as any to do a little bit even more of a deeper dive. I know you touched on it briefly, but what sort of legal issues are something that you've seen cropping up that would be especially applicable to nonprofits? And maybe what are some of the pitfalls that they might not be thinking of that they should watch out for?
Sure. So, one issue I think that is on a lot of people's minds, there have been some news articles and stories coming out about customers in stores or employees really pushing back on the face covering issue. People having really strong feelings about whether they should be required to wear a face covering or not. At least in Ohio, with dealing with employees, the state has kind of taken that burden off of employers as far as making the call. It's required by the new Stay Safe order. So if you have employees coming into your workplace, unless they are in an office by themselves with the door closed or in some other sort of enclosed area by themselves, they should be wearing a face mask. And that's something that you should be enforcing as an employer. In addition, I mean, sometimes there are wage and hour issues that arise with dealing with protective gear that employees have to take on or put off. Obviously, face covering is pretty straightforward, but if there's a process of coming into the workplace, getting your temperature taken, putting on protective face covering, those things are most likely going to be principal activities that should be compensated for. So if you have somebody coming in and they're required to have their temperature taken, required to put on a face mask, that's time that's when the clock should start for them as an employee. Make sure they're being compensated for that time. There are some other kind of wage and hour related risks, I think, that will arise as these Stay Safe order gets put into place. So the Stay Safe order encourages employers to stagger shifts or change break times or shut down kind of common areas where people are eating or taking their breaks. So to the extent you have employees who are taking unpaid breaks for lunch, if they're now doing that at their desk or at their workspace, they're much more likely to get interrupted. And if they're interrupted or if they're tempted to do some work while they're eating, that makes that time compensable. So it's gonna take some communication with employees to make sure they understand they shouldn't be working off the clock, and that if they are working, they should be recording and reporting that time. So there's some some compliance issues that I think are going to shift a little bit as employers, including nonprofits and organizations who have employees come back to offices, are going to face as they try to adjust kind of how they operate.
Is there any responsibility on the part of the employers to provide any of this protective gear?
So my understanding is it can be provided either by the employer or the employee. Todd, maybe you have a sense of whether the employer has to provide it. If an employee doesn't, I mean, I think the issue is going to be if they don't have it, they can't really be in the workplace if they're in a place where they need it.
Right. I would, to answer that question, I would divide the world into two different spheres. One being healthcare, the other being everything else. In a healthcare setting, especially, you know, hospitals and you know, frontline, you know, healthcare workers that are responding to the COVID-19 crisis and interacting with patients who have it or may have it. Yeah, there's and it's through CDC. CDC guidance requires, you know, a whole array of PPE that employers need to be providing. But once you get outside of that sphere, no, there's no mandate that employers provide the PPE. But I can tell you, as a practical matter, as an employer, if you're resuming operations under the under responsible restart, while it may not be mandatory, it sure is a good idea to try to get your hands on a stock of face coverings. Yes, you can require employees to bring their own. I mean, it's a bring your own party, but as the employer, I think it's good to have a stockpile that's handy, because, you know, inevitably people will forget them. They'll leave them in the car. They'll, you know, for whatever reason, maybe not be able to procure a good face covering or not figure out how to make one. So as an employer, I think it's good to have a supply, and I know they're hard to find. And so that just means, you know, seemingly endless hours searching Amazon, trying to find a supplier who's not going to gouge you. But that's worth the effort, because I think it's a good backstop to have a decent supply of those on hand.
So I hear you say that it's a good idea. Do you think there's any potential liability down the road if you know, they're not able to provide it? I mean, is that on the employee? Is that on the employers? In your situation, say they forget their masks at home and it's not provided. Do you think at that point it's better for the employer to send them home, or what sort of best practices would you recommend?
Yeah, for the employee who forgets the mask at home, or maybe, you know, the dog ate it. Yeah, it's and certainly under the new Stay Safe Ohio order. Yeah, that employee cannot enter the workplace that day, so they should be sent home. In terms of liability, I think there's fears of employer liability, I think, are at least at present, and it all could change with the next, you know, governmental pronouncement or act of the legislature. But I think in some ways that those fears are overblown, especially because you know, the Ohio's Bureau of Workers' Compensation issued a statement back in the middle of March, basically indicating that it's going to be very difficult for an employee to successfully file a workers' compensation claim based on, you know, this idea that I got COVID-19 on the job. And that's because workers' compensation law, while it does cover occupational diseases, the key word in that phrase is occupational. You have to work a job where the job itself and the demands of the job enhance your exposure to the disease. Now, in healthcare, that might be, again, that's a kind of a different world. But for outside of the healthcare sector, I think it's going to be very hard for employees to successfully prove that they contracted COVID-19 on the job. And then a second avenue for an employee to try to pin an employer with liability for a workplace injury or disease is what's called an intentional tort theory. But that's a very, very high standard for an employee to prove, and would really require an employer who is just completely blows off every conceivable social distancing and other kind of preventive measure that have been recommended and mandated. And I mean, never say never, but I would be surprised if there are many employers out there who are just completely blowing off all of this.
So we've talked a fair amount about what don't do, and you can avoid liability. But Todd, if you don't mind, since you're heading up at your firm sort of the best practices for your return to work, would you mind outlining just what should nonprofits think about? What's a good plan? What are just some good things that they should do over these next few weeks if they are planning to invite people back to the office?
Right. And I like your use of the word invite. That's a nice segue to the probably, I think, one of the keystones of my firm's plan is that it is not mandatory. Now, granted, we're in an industry that lends itself pretty well to work from home, but we certainly we don't want anyone to feel pressured to return to the office, especially when they can work from home. But there are some categories of employees that we are urging to stay home. In fact, we've told them not to return to work starting May 11th, and those are persons who are over age 65 or who have a health condition that makes them especially vulnerable to bad outcomes if they were to get COVID-19. Or for that matter, if they live with someone who's has those vulnerable medical conditions. Second, employees who need to be home to care for a child who would otherwise be in school or at daycare. You know, we don't want them coming to the office. A third category is employees who rely on public transit to get to the office. Public transit is, I mean, it's probably more of a problem in much larger cities like New York, for example. But public transit can be, you know, obviously just a very germ-heavy environment, and so both for the employee's own well-being, but also for the well-being of that person's coworkers, we're urging people who rely on public transit to get to the office to work at home, or you know, we can work with them on other arrangements to get to the office. And then kind of a fourth category is just persons who, for whatever reason, I mean, they might not have a health condition that makes them vulnerable or fit in any of these other categories, but for whatever reason, they're just not comfortable coming to work yet. And I think that's a recognition that this is, everyone processes health risk differently. And you know, some folks tend not to worry about you know, health issues much at all, whether it's a virus like this or something else, whereas other people do. And so we're trying to be respectful of that. And so we just, you know, if you're not comfortable coming in, then that's fine. Stay home and continue to work from there.
So once they are back in the office, and assuming that it's this staggered, only the people who have to, only the people who can coming in, what are some best practices for once they do start coming back to the office?
And again, this is, I should preface all of this. You know, we're a general office environment, which I think is, in some way, it's much easier than if we were in manufacturing or retail. But I'm also hoping that a lot of our listeners today probably have fit in that general office category. Yes, you've got operations and kind of people out in the field, and that's a whole nother set of considerations, but at least for your general office operations, we have a split squad. We've split the firm in two, and we're working alternating weeks. So, Team A is in the office, the first week, and Team B is at home, and then the next week it flips, and so on until, whenever this ends. But the other thing we're doing is, upon entry to the building, employees are subject to a quick, just kind of assessment that includes temperature screening and just answering, 3 or 4 very quick questions about how they feel. A lot of the temperature covers the fever, but the other questions are other symptoms of COVID. Do you have a cough? Are you experiencing trouble breathing? And then of course face coverings, and then even once they pass the initial screening, we just have implemented a variety of social distancing measures that kind of go beyond the minimums of the state order. And this is one of those things, if I encourage everyone out there, just sit down and think about your operations. I mean, how people move about your office. Where do they congregate? And then what measures can you take to reduce that? What are heavy touch points? And then attack those areas with a lot of cleaning and disinfection. Just get creative in terms of creating more distance between people, and even in creating less interaction among the people that are there. Something we've tried to tell people is that, even once we come back, it's completely different rules. It's not, you're not going to, it's not going to be a lot of, hanging out at somebody else's workstation, just shooting the bull. We really want to discourage face-to-face conversations. But yeah, just get creative, because as you really hone in on your operations, you'll start, these things will just come to you. You'll start thinking of lots of little ways that you can increase distance and minimize interaction between people.
I'd love to jump back, and Russell, if I may toss this over to you. Going back to the health screenings, are there any legal issues about, maintaining confidentiality of that medical information that employers should be wary of?
Right. Yeah, that's a really important issue. So normally employers don't collect this kind of information or collect it on a daily basis, and there are restrictions under the ADA and under state laws from making these sorts of inquiries. Because we are in a pandemic situation, it's permissible and even encouraged for employers or required for employers to be doing these sorts of assessments. But that doesn't change the fact that it's medical information that's being collected. It needs to be kept confidential under the ADA. So really, if you're keeping any written records of symptoms or temperatures, those should be kept in a separate file. It's under lock and key from kind of the regular employee files. You should also take steps to make sure that, if you've got employees waiting in line for their screening, that their temperature or their reporting of symptoms isn't something that other employees can see or overhear. And if there is some sort of need to communicate, perhaps an employee has a temperature and it's sent home for the day, that reporting of information should be kept as limited as possible. So you might need to tell the supervisor or manager this employee is being sent home due to some symptoms, but you want to keep that information limited as far as what you're communicating and who you're communicating it to. So, take the normal steps you would with any other medical information that you're getting from an employee. It's just, this is an unusual situation where it's a regular collection of this information. And I think that, it's easy to kind of think, oh, this is not something we need to be as careful with, or you're also taking it in a situation where there might be other people around who can see or overhear that information. Just take steps to keep that confidential and maintain that privacy for employees.
Thanks, that sounds good. If I may, I want to sort of go back as we were talking about responsibilities for employees to return to work and employers to ask them to come back. We got a question from one of our participants. Can a social worker who does home visits refuse to work due to fear of contracting COVID-19? And then how should an employer handle this?
Sure. So there's a few different issues going on with this. So if you have somebody who is afraid of contracting COVID-19, that isn't something that in and of itself is going to provide a basis for, say, a reasonable accommodation under the ADA or under Ohio anti-discrimination laws. So, however, if that fear is based on, some sort of immunocompromised state that they may have, or a disability that they have that makes them more likely to contract COVID-19, that may be a basis for some sort of reasonable accommodation in the form of leave. That may also make them eligible for paid sick leave under the FFCRA, which came out back in March. So there's a little bit more analysis that needs to go on. If it's just purely based on that employee's fear, I think, like Todd was talking about earlier, you want to work with that employee. It's understandable that people are fearful and don't want to be in those situations. So I think it's good to be creative about finding solutions for people in that situation. But as far as a legal obligation to provide them with paid leave or provide them with an accommodation, if it's just based on their kind of fear of the general risks in the workplace, that's going to be kind of a separate issue that they may not be entitled to.
This reminds me that another good topic that we want to address in this particular situation with our nonprofits are any potential ADA, FMLA issues that they should watch out for. Any other issues of accommodation or leave, that any advice that you want to share with our participants today? And this is open to anyone. Russell, Todd,
Okay.
Jackie, anything
Yeah,
that you want to jump in.
I can start. Yeah. So, I think some of it's really uncertain. So we don't know what the long-term effects of COVID-19 are. So it's possible, if we find out from research and from seeing this kind of emerge that there are long-term ongoing respiratory issues or, other health issues that stem from this, then it's possible that falls into the category of a disability that would require an accommodation. Generally things like the cold, the flu, those sorts of things aren't going to be considered a disability under the ADA or state law for those purposes. But we don't really know enough about it at this point to make a firm determination about whether that's going to be considered a disability at some point in the future. And I think with FMLA, again, you have to evaluate it in the same way you would anything else. So if it's something that there's 3 days of incapacity related to it or requires some sort of ongoing treatment, you look through what the FMLA says about what a serious health condition is. You analyze it in the same way you would any other illness, and then determine if you need to, provide that type of leave. And then also, of course, you have to analyze it under the paid sick leave and paid childcare leave statutes that have come out, and determine, whether that person may be entitled to leave on that basis.
So those are all good, very good points on staying on the right side of the law. Is there anything else that any of our panelists would say is a recommendation? Like, you might not be required to, but this is going to be a really good idea for you.
I would add that to keep in mind, there's, I guess one goal of our, of return to work protocols or office reopening initiatives is, obviously as an employer, you want to get people back. You want to get people back to work, and because I think work from home probably works for some some entities better than others. But you know, even for the most smoothly operating work from home environments, I still think it's something of a Band-Aid. I mean, we can make it work and get by pretty well, but I still think, you know, the day when offices are at full staff, you know, every organization in America is going to be a lot more efficient. But so that's kind of one goal. But I think another goal in these return to work plans is making employees feel comfortable with the return to work, making employees feel that you as the employer are taking, you know, are you know, using an abundance of caution and going above and beyond the bare minimums, so that when people come in, you know, they will feel that, all right, my employer is doing everything that they can possibly think of and reasonably afford to make my return to work as safe as possible. I think in a lot of ways, this is an opportunity to build goodwill with your employees. You know, again, it's kind of a shared mentality. We're all going to have to get through this together, but that's it's a whole lot easier to get through this together if employees feel that the employer is doing its best.
Yeah, absolutely. I would love to jump in here. We did have another question from our participants going back to the requirements around taking those temperatures and medical information when employees come back to the office. So the question that we had is, when taking temperatures, could you just keep track of passed or failed, you know, i.e. Passed if normal, failed if high, and then would probably be sent home anyway on high? Do we have any more guidance about what that looks like?
Yeah, I'll jump in on that, and I'll share what we're doing. Yeah, we're not recording the precise number of the person's temperature. It's really just kind of a you know, it's a pass-fail test, and that's what that. But we are keeping a daily record of it, especially so that we could help with, you know, in case someone does develop it and the Department of Health, you know, makes a visit or calls to do contact tracing. We want to be able to, you know, state that, well, on such and such date, this person, their temperature was fine. You know, we admitted them into the office. Obviously, if someone if someone doesn't pass, you want to handle that discreetly. I mean, there shouldn't be like a siren and red lights that start going off so that
nobody tackles them from the side, or okay.
Yeah.
Right. If they fail, Todd, would they be required to go to get testing or just stay home? And do they need to then report that response back to the employer?
Well, the immediate step is, yes, send them home and urge them to seek medical review, medical treatment. And to the extent that includes testing, then yes, a negative result would allow us to return them to work quicker. But if for whatever reason they don't seek medical attention or don't seek a test, then we're going to require them to stay home until the CDC guidelines state until 72 hours has passed without a temperature, and that's unaided by Tylenol or Advil or other over-the-counter medications.
I have a question for, you know, Russell and Todd, just on the privacy concerns of employees. And you spoke a little bit about contact tracing. Do you need to disclose anything to your employees? You know, if there is more information that you're sharing about like who they were in contact with while at work? I expect there's no expectation of privacy when you're at work, but do they then have to turn around and tell you what they're doing when they're at home? Like, I went to visit this relative, it was under 10 people in our home for a gathering, you know, nobody else has gone. Are you inquiring from your employees where they went before they even come in? Either one of you.
So I think that the stay safe order, and Todd, you can jump in as well if you have thoughts on this, but I think that what that's requiring is that employers report that to the local health department, and then the health department is going to do the contact tracing. I mean, they may ask the employer to cooperate and say, what, you know, in your workplace, what other employees has this person been in contact with? What customers has this person been in contact with, or vendors? So there's going to be a level of cooperation, but I think that's going to be led by the health department and not the employer. And the employer, to the extent they can, should really stay out of that. I mean, I think that, I mean, maybe it makes sense to, you know, issue a set of expectations to your employees generally about, you know, we expect that you're going to be abiding by the stay safe order, that you're not, you know, going to gatherings of larger than 10, that you're, you know, practicing social distancing because we want to keep the workplace safe, and kind of set those expectations. But I wouldn't recommend that an employer go around trying to kind of dig into, you know, off-duty activities and enforce that themselves. So.
Yeah, I agree. Let the state or local board of health tackle those jobs.
I'm sorry if I already missed it. Is there a responsibility on the part of the employers, say one of the employees is unfortunately either diagnosed as having COVID or high likelihood that they have it? What's their responsibility to tell any of their coworkers with whom they may have come into contact?
Yeah. So, I mean, I think, again, the first step is contacting the health department. I think one of the things that is mentioned in the order is that the health department will help kind of coordinate those communications. I mean, I think there should be communications to your employees if, you know, a coworker is diagnosed, that, you know, again, not disclosing confidential health information, but giving them the information they need to kind of feel at least some peace of mind or understand what their next step should be as far as, you know, isolating or seeking diagnosis or that kind of thing.
Yeah. Or that is as to employees who have been in close contact with the afflicted individual. There's no need to, and in fact, employers should not be, you know, you shouldn't issue a memo to all hands saying Todd Palmer tested positive for COVID this morning. Everyone, you know, freak out.
It goes in the category of don't tackle them at the door. Okay.
Yeah, exactly. That's right up there with, yes, don't have a siren and a red light that goes off at your temperature monitoring station. But certainly, and Russell's exactly right. This is one where as an employer you're going to work in concert with the contact tracing personnel from the local Department of Health. And that's probably going to mean identifying, you know, reaching out to employees who may have been in close contact with the afflicted individual, and letting them know that they've, you know, on last Tuesday you worked, you know, for 3 hours side by side with the afflicted, with Todd Palmer, and so, you know, we advise you to you know, go get tested and, you know, take the time you need to make sure that you're not positive.
I know we don't have a ton of time left. We've got just over 15 minutes. So I want to get to some of our other really important issues that I know that we wanted to talk about. Do we have any further thoughts? I know as we go further and further into the shutdowns, nonprofits especially, unfortunately, are facing layoffs and furloughs of employees. Are there anything that you want to, any thoughts that you have about this, words of caution to the nonprofits, anything that you've seen crop up in your practice that you think that they should know? Open both to Todd, Russell, any of our participants.
I mean, I guess a couple of thoughts related to unemployment or laying people off or furloughing. Um, I mean, at the moment, with the kind of federal kick-in of $600 a week for unemployment, there are a lot of employees who are actually in a better situation if they're otherwise eligible for unemployment than they might have been while still employed, at least from a monetary standpoint. So that's something to bear in mind. That I think is available through the end of July, the federal bump to state unemployment funds. One thing that employers can provide is some sort of furlough or temporary layoff where, you give kind of an indication that you want to bring this employee back, but for the time being, due to operating expenses or level of work that's going on, you can offer them a furlough or temporary layoff. When you are communicating those things to, if you get a request for information from the Unemployment Compensation Bureau in Ohio, you want to make sure that you're indicating that that's something that the employer is offering due to lack of work or operating expenses or that sort of thing. And sometimes you have an employee who comes to you and says, "I'm afraid of coming to the workplace," or something like that, and and you may offer them a furlough that's also based on kind of the lack of work that your organization has at that point, and then that's what would provide the basis for unemployment compensation. If it's kind of communicated in the sense that, like, we gave this furlough because this employee was afraid, then there's more likelihood that unemployment compensation request is going to get kicked back. But I am seeing a lot of employers who are offering temporary layoffs to kind of weather this storm, both from the organization standpoint and also it can be a good option for the employees as well, with, at least while that federal bump is still kicking in. It makes it a little bit easier blow to kind of take, even though it's difficult to be in that situation.
Yeah, one thing I would add to what Russell just said with respect to the unemployment booster, for the organizations that have gotten payroll protection program loans and are concerned about the forgivability piece of that, and there is a provision in the PPP for rehiring employees that were laid off or furloughed during this time and becoming eligible for the potential forgiveness. That's certainly something to think about, but I think that we also need to be careful, and I've had this conversation with plenty of clients, be careful about chasing that forgiveness at the expense of what makes sense practically and financially for your organization. And in some cases for your employees, as Russell mentioned, you'll find that in some situations, those employees are actually better off on unemployment for the time being. I think the other thing we need to think about is, here we're in the responsible reopen process, but it's going to be very much a process. And for most organizations, some more than others, it's not going to be like tomorrow, everything's back to normal and fully staffed, fully operational. So don't rush. If you're one of the lucky few that got the PPP loan, don't necessarily rush your employees back just so you can get that forgivability. The PPP loan terms are still pretty favorable. Of course, you have to repay them. It's not completely forgiven, but it has to be part of the calculus. So just want to throw that in there, that's part of a sea of lots of different things you have to think about, and we recognize that. But it's make sure whatever you're doing makes sense in your game plan. That game plan may have changed relatively recently as things are unfolding. But whatever your plan is for getting back on your feet as an organization, make sure that all fits in with that.
Just for a question on the PPP loan and rehiring, is it just headcount in terms of number of employees? Because your employee may prefer to stay on unemployment or have gotten a new job because they really just couldn't hold off on.
Yeah, so that's a good.
To your organization, what is that for your organization?
So that's been an open question for a while, but SBA just issued within the last couple of days an additional FAQ on that very question. And my understanding is that that the SBA and Treasury will look at that kind of situation as you did what you could to bring the person back. And if it's by no fault of your own as an organization that that person did not return, then you will essentially be considered, that person will be considered to have returned for purposes of forgiveness. So you'll have to document that, and it's still not totally clear how that's going to play itself out. But that was a question, because we've had that question a number of times, and in the last 24, 48 hours, we've gotten at least some guidance that that they're going to take a practical approach.
So we have a question from one of our participants, and this may be a little outside of everyone's experience here, but wanted to at least see if we could get this posed. We've got a group that works with formerly incarcerated individuals trying to go back to work. So in light of the fact that, traffic courts, many of them are still closed, or at least very, very much limiting the ability to get in, BMVs are closed. Do we have any thoughts about what happens when you have an employer who is looking to hire people? They meet every other level of eligibility, background check, drug screening, et cetera, but they don't have a license that they would have been able to get if the courts were open, or if they could get into the BMV. Do we have any thoughts about what employees can do, what employers are required to do? Can they deny the chance to work for that person, for that company, if that license is the only thing they're missing in these circumstances? Thought I'd toss it out there. I know it's a little bit outside of most of our areas, but if anyone has any thoughts.
I'll take a stab at it, or at least part of it. If the job requires driving, then yeah, the absence of the license, I think, makes it impossible to hire the person. But if the driver's license is just needed for, say, proof of identity, for, say, filling out an I-9, I mean, there's multiple forms of identification can satisfy the I-9 requirement. So, I mean, it doesn't require, a driver's license and nothing else. So I think in that sense, I would explore alternatives with the employee or the new hire.
Makes sense.
Yeah, the only thing I would add to this is more of a general response to a specific question. So lots of things, deadlines have been moved. There have been lots of different requirements that were set to go in effect. That's implementation date has been delayed. But unless there's a clear statement that something has been delayed, or that a restriction has been temporarily loosened or something like that, we have to proceed as if the rules are still in place. So if there are rules that are in place and you don't have an explicit statement from whatever the regulatory or state or local agency is that promulgates those rules, the rules still apply. And so I would much rather, and certainly we lawyers are always going to say, it's better to follow the rules now than to assume that you'll get leniency later. That's a dangerous game. So just again, a generalized comment, but that made me think about, that specific question made me think about the importance of at least saying that for the record in this conversation.
Absolutely. So keeping in mind that we have just a few more minutes left, Jackie, I wanted to give you the opportunity. I know that you had some updates about annual reports for nonprofits. Anything that you'd like to share before we wrap up?
So I'm pretty sure most of the nonprofits here would have had their interested parties receive an automated email from the Ohio Attorney General's charitable registration system, their FOIN system, saying your annual report is due, but now extended. So the former due date for fiscal years ending December 31st would have been May 15th this year for your annual report. That would have been Same with your IRS 990 report due too. Those have all been extended to July 15th. So it may have been hidden on the very bottom of your emails, but also know that it would have said your new due date is July or whatever your extension date is for that. Some of the nonprofits we know are on other fiscal years. So it's generally 5.5 months after that. So you really have to take into Alex's advice. If your due date did happen to fall during the shutdown, the IRS extended your due date. But otherwise, if your due date is coming up past July 15th, you still have to file on time your 990s and other charitable registration reports to the Ohio Attorney General. Right now, they are not taking phone inquiries into registration. So if you have a new nonprofit that just received their tax exempt status and had questions on how to register with OAG, they're kind of unavailable by phone, but you can email them still. And then I don't know if there's some nonprofits that are kind of direct service, frontline providing food, security for housing, but all of those entities look to the Cleveland Foundation and that COVID-19 Rapid Response Fund because those grants are going out weekly.
Wonderful. Thanks
That's
so
my
much,
update.
Jackie. With just a minute or so left, does anyone else have anything else that you think would be really important for our nonprofits to know at this time? Otherwise, we will see them again in a month for our next Reach Out Live. Any last words of advice? Okay. So what I'm going to do now is just make sure that everybody knows that we are recording these sessions, including the one that we did earlier in April. They are viewable at any time from the Cleveland Metropolitan Bar Association's Facebook page. We will also have a link to this from the Bar Association's Reach Out for Nonprofits program page. And as a reminder, our website is clemetrobar.org, and you do /reach out. We have a lot of resources there for the community in general, also resources specific to nonprofits, and we have links and registrations for past and upcoming Reach Out Live. I want to thank our panelists again so very sincerely for joining us. I learned a lot. I really hope our participants did. This has been a great session, and we cannot say enough how much we appreciate you being here. If any of our viewers have any follow-up questions, anything else that you need help with, please do give us a call at the Bar Association or email me directly. My email is jpayne, P-A-I-N-E, so jpayne@clemetrobar.org. I'm going to put it up on the screen in the chat box there as well. But please, I encourage you to reach out to us. Reach out, we'll, no pun intended, we'll keep putting on these programs and offering help for the nonprofits in our community that we know you guys are doing really great work out there. So,
Can I answer the question that's open right now? Are you considered a nonprofit if you only filed with the state? You're incorporated in state as a nonprofit, but you will not have your tax exempt status federally recognized by the IRS. So you have a limbo of you can't take deductible charitable contributions as your bottom line for that, but you are a Ohio nonprofit organization or corporation is most likely what you've done. So you really do need to follow up to either determine if you have to file for a 1023, which process you would do for that.
thanks, Jackie. Really appreciate your quick eye on seeing that. With that, it is 11 o'clock. Thank you everyone for your time, and we will see you again next month. Take care.
Thank you.
Thanks, everyone.